eager learners, and distinguished experts who continue to shape the communication and other skills. On behalf of Retd International Business School, I extend my heartfelt gratitude to our esteemed guests, faculty members, and students for being a part of this enriching session. I take this opportunity to extend a warm welcome to our honored guest and resource person. Before we introduce our esteemed speaker, allow me to take a moment to introduce the institution that has made this event possible. Retd International Business School, established in 2004, it has been a beacon of academic excellence and professional development. Affiliated with Guru Gobind Singh University, Delhi, and approved by the All Indian Council for Technical Education and the Bar Council of India. GIBS offer a range of distinguished programs including MBA, MBA International Business, MBA Integrated, BBA Honours, BA LLB Honours, BBA LLB Honours, and LLM. With an unwavering commitment to education and research, GIBS has consistently been recognized for its excellence and has been rated A by NAB in its third cycle. Now, it is time to introduce the esteemed expert who will enlighten us today with his invaluable insights. Shri Sukhdev Singh, retired Additional District and Sessions Judge, acquired his formal education from Punjab School Educational Board and Guru Nanak Dev University, Amritsar, and higher education from University of Delhi. He joined the Delhi Judicial Service in the year 1985 and was promoted to Delhi Higher Judicial Service in the year 2000. He has worked in several capacities on original and appellate jurisdiction, both of civil and criminal side. He has presided over special courts like Motor Accident and Claims Tribunal, Labour Court, Matrimonial Court, and Special Court under Electricity Act. He demanded the office of District Judiciary in the year 2015, and after superannuation, he worked as a president of Consumer Court District, Delhi till 2020. He has attended various national and international seminars and conferences. He is the author of 2 books, Cognizance of Offences by Criminal Courts and Hindu Law of Marriage and Divorce, a LexisNexis publication. To express our deep appreciation for Sir invaluable presence, we now present a green welcome, a small yet meaningful gesture to celebrate our commitment to sustainability and growth. Now I invite Dr. Neelam Singh to present the green welcome. Without further ado, I now invite Sir to take the stage and share his invaluable insight with us.
Of the faculty and the students, I am deeply obliged to be here for having a talk on the topic Police Accountability and Custodial Justice, New Safeguards under BNSS. The police accountability starts from the day when a person is arrested. The preamble of the Constitution of India says that we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them for guarantee assuring the dignity of the individual and the unity and integrity of the nation. To give effect to the sovereign affirmation made in the preamble, the makers of the Constitution provided fundamental rights and listed in Part 3 of the Constitution. These rights are right to equality, right to freedom of religion, etc. However, the right which have direct concern with the police accountability and custodial justice is the fundamental right enshrined under Article 21 of the Constitution of India. Article 21 of the Constitution of India provides that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, we have to see what is the concept of justice. The preamble have justice, social, economic and political. The first thing is we have to know what the concept of justice is. The concept of justice broadly is of two types: substantive justice and procedural justice. Substantive justice is about ensuring fair and just outcome by following the law. However, the procedural justice is following the progress of the process to achieve substantive justice. To achieve substantive justice, the fairness of the procedure is important. Accountability, police accountability and custodial justice. The first case which has been decided by the Honorable Supreme Court is B.D. Basu vs. State of West Bengal, which stands as a watershed movement, a judicial pronouncement intended to stem the tide of custodial violence by establishing unequal guidelines for arrest and detention. This was the first case in which the police accountability was considered by the Honorable Supreme Court. Now the custodial justice, as far as the CRPC is concerned, CRPC Code of Civil Procedure 1973, as well as the new BNSS, deals with the remand concept. Remand means when a person is given to the police or judicial custody, then it is said to be a remand. It is the concept of remand. The custodial and accused is of two types: police custody and judicial custody. Police custody is when the accused is given to the police for interrogation. It is called the police custody. And the judicial custody is when a person is sent to the lockup or jail after completion of police custody. Then it is called the judicial custody. Of the police starts with respect to the accused from the very beginning when he is arrested, and the provisions which were in the old CRPC as well as BNSS have kept in mind that the accused should be protected. Section 56 of CRPC provides that the accused is taken to the magistrate after his arrest. When an accused is arrested, it is the duty of the police to produce before the magistrate. Then Section 57 further provides that he is to be produced within 24 hours. This is also accountability towards the police. Then comes Section 167 of CRPC. Under this provision, the accused can be taken for investigation, praying for police custody. Police custody is when the accused is kept with them for investigation. This custody was maximum for 15 days in CRPC and under BNSS, again it is kept as 15 days, maximum 15 days. Then there comes the judicial custody. When the police has no role to play with regard to the investigation, and it says that the accused is not required for further investigation, then the magistrate sends the accused to the judicial custody. Judicial custody is the custody when the accused is remanded under the orders of the magistrate and sent to jail. Where the investigation cannot be completed within 90 days, if the offence is punishable with death, life imprisonment, or imprisonment up to 10 years, the accused has to be given bail. Meaning thereby that if the investigation, police cannot complete the investigation within 90 days or 16 days, depending upon the punishment which has been provided under various provisions of CRPC as well as BNSS, then the accused has to be given the bail. It is called as a default bail. Then these were the provisions which were under the CRPC, and BNSS have similar provisions. The only difference which has been made under BNSS is that the 15 days, maximum 15 days period has been kept as it is. However, the custody can be changed. In the earlier CRPC, the 15 days were at a stretch from the date of arrest till 15 days. Within these 15 days, the police was required to ask for police remand. However, this has been changed under the new BNSS. 15 days can be, police remand can be taken for maximum 15 days, but it is interchangeable. First, they can take for 4 days, the accused can be sent for judicial custody. Then even they can ask for police custody when the accused has been sent in judicial custody. However, a limit has been put under this, 40 days or 60 days. Within these 40 or 60 days, they can ask for interchangeable remand. This interchange of remand has been put in the new BNSS on the basis of a judgment decided by the Honorable Supreme Court in V. Senthil Balaji versus State, represented by Deputy Director and others, which took the view that 15 days police custody could span the entire investigation period, 60 or 90 days, rather than being confined to the first 15 days post-arrest. This ruling has paved the way for enactment of Section 187 of BNSS, which explicitly allows the 15 days of police custody to be taken at any time during an extended period of 40 or 60 days. This has put the accused at a disadvantageous stage. Both these provisions balance the rights of the accused and the power of the police investigation. The remand authorizes temporary detention of the accused with the investigating agency with constitutional rights of the accused. With regard to the procedure, fairness of the procedure, the Honorable Supreme Court in Maneka Gandhi versus Union of India took the view that the procedure must be just and fair. It must not be arbitrary, fanciful or oppressive. Then with regard to the judicial view, which has been taken by the Honorable Supreme Court towards police accountability. The first landmark judgment which I have already stated was BK Basu versus State of West Bengal, where it was said that custodial torture is a calculated assault on human dignity and cannot be permitted in a civilized society. The right under Article 21 cannot be suspended even during an investigation. From this it flows that the custodial justice was also performed by the Honorable Supreme Court in this judgment. Then comes the Sunil Batra versus Delhi administration, where it was also stated that prisoners and detainees are not to be treated as non-persons. They retain all rights enjoyed by free citizens except those necessarily lost as an incident of confinement. This landmark ruling addressing prison conditions gains renewed significance in the light of various deaths which are occurring during the judicial custody. Then comes the V. Senthil Balaji versus State, represented by the Rector and others. The court expanded the possibility of police custody beyond 15 days limit established by Section 167 of CRPC. The court overruled the earlier 15 days custody restriction rule in CBI versus Anupam J. Kulkarni and allowed the police custody to extend across the entire investigation period, which could last up to 60 or 90 days, depending on the gravity of the offense. So these are the provisions which were earlier in CRPC and now which have been incorporated in BNSS. The only difference which has been made with regard to is that police custody can be taken even if the accused has been sent for 3 days. Now the maximum period is 15 days, but this 15 days period can be taken by the police for police custody when the accused was sent in the judicial custody. So meaning thereby that it is interchangeable. This period of 15 days is interchangeable. This is the only difference which has been made with regard to the police remand. So these are I have taken only these provisions for police accountability and judicial custodial justice. Now there are other provisions also, but within this 1 hour period, it is not possible to look into other provisions. Now it is for you to see other provisions. You being the students, you have to take all these things and learn with regard to these rights of the accused, which flow from Article 21 of the Constitution. With this, I close my topic and thanks all the faculty members as well as to the students who are present here. Thank you. To the students is that you should have the mastery on the procedure. It is the procedure which is more important in the court proceedings. You should have the mastery on CRPC, which is now BNSS, and CPC, which deals with the civil cases. So there should be thorough understanding of these provisions, because if you are entering the service or entering the bar, these are the two procedural statutes which have to be given more importance than the Evidence Act also. Three things are very important for judicial service as well as for entering the bar. Thank you very much.
Session, sir. Your knowledge and experiences have truly broadened our perspective on police accountability and custodial justice. New safeguards under BNSS. As we conclude this remarkable event, I take this opportunity to extend my heartfelt gratitude to Sir for his time, wisdom, and inspiring contribution. I now invite our respected faculty, Mr. Raghav sir, to present memento and thanks letter as a token of gratitude.